People v. Baez.
Good afternoon, Your Honors. Harold Ferguson for Appellant Melvin Baez. We would request 2 minutes for rebuttal.
Yes.
Contrary to the Appellate Division's decision, the people did not establish by legally sufficient evidence that the item that Officer Lynn allegedly recovered from the ground at the scene of Mr. Baez's arrest was the exact item that criminalist Cesario received and tested at the lab. The bottom line was, Officer Lynn indicated that she recovered a badly torn open bag that was so badly damaged that the white substance that was within it was pouring out. As a result, she took that single bag, put it within a latex glove, tied it shut, and later delivered it to an office at the 113th Precinct. But at the 113th Precinct, all she did was take that single latex glove and put it in an unsealed envelope. Although there is...
So is there evidence that what was put in the envelope was somehow in a different condition than that which it was when she put it in there?
Absolutely, Your Honor, because when Officer Lewis comes and retrieves the envelope, what he finds within it is not a single latex glove, but 2 items.
Does he say it's not in the condition that it was?
He says there is within the envelope, there is a latex glove and another bag. Officer Lynn did not put 2 items in that envelope.
And where is that item in between? In between when she puts the item in the envelope and when the next person picks it up?
It is it's an unsubstantiated period of time between the time Officer Lynn leaves the precinct.
And the envelope is where?
Is on a desk where there is supposedly some anonymous officer who's supposed to safeguard evidence. But there is no evidence in this record that in any way did Officer Lynn...
So were they required to call that evidence officer?
What they needed was at least some type of indication that Officer Lynn spoke to that officer, told that officer what was there, and to safeguard that evidence. There is nothing in this record to indicate anything regarding the safety protocols in that office, who had access to that office. And when Officer Lewis comes hours later to the office, he does not talk about any security protocols in that office and does not mention that there is a single other officer in that office. So there is a period of time where we don't know who is supervising this. And what we do know is that when Officer Lewis picks up the envelope...
So when you're establishing chain of custody, you have to call every single solitary person from the time they took it out of the car, I'm sorry, from the time they retrieved it, every step in between. Anyone they encountered, they must call?
No, Your Honor, that's Julian and Connolly do not require that. But what you have in this situation is that in Connolly it talks about when there is an undisclosed person who had access to it, and which we have here, and that there is a period of time in which there is nothing that describes who is supervising this. And most importantly, when Officer Lewis comes to the precinct, what he finds within the envelope is 2 distinct items.
Before he opens the envelope, Officer Lewis goes to the desk to take the envelope.
That's correct.
And he finds it exactly where Officer Lynn said it would be, doesn't he?
Yes, he does. But what Officer Lynn said she put in the envelope is not what Officer Lewis finds in the envelope. What Officer Lewis finds in the envelope is 2 items, the plastic bag and the latex glove.
So then what matters for your argument is these inconsistencies in the testimony, that not whether or not one knows, was there a person there, where the envelope was placed, what's the name of that person, do they need to testify? It's these inconsistencies that suggest some other problems in this chain of custody?
Absolutely, Your Honor, that there was the possibility of tampering and that we do
There were no inconsistencies, and we still didn't know all the things you've already pointed to. Would you still have an argument on the chain of custody?
Could you repeat that, Your Honor?
Sorry. If there were no inconsistencies in the officer's descriptions, and I think her name is Ocasio, Osorio, whatever the criminalist identifies, But we still didn't know about the placement of the envelope, whether or not someone was in that room, whether or not someone else entered that room and touched that envelope. If we didn't know those things, but there weren't the inconsistencies that you've very clearly pointed out in the briefing, is there still an argument about the chain of custody?
Yes, there is, because there is nothing in this record that indicate that what should have been sent to the lab for testing is the latex glove. That was sealed as a singular item, and there is only a single bag that's supposed to be within it. There is no description of Officer Lynn of having 45 glassine bags or anything else. And
I think Judge Rivera was asking you a different, sorry, right here, it was asking you a different question. That is, suppose what we had is a single bag, there's no discrepancy at the site of the arrest about what was collected. It's described one way with this, weight that, the officer estimates that the same weight that the criminalist weighs, that the condition of the bag is exactly fine, that the sticker carries through. The only defect is it was placed on a desk in an envelope. We don't know who was there. We don't know how much time elapsed. That's all. If we just had that, would that be a chain of custody problem?
I don't think it would be a chain of custody problem because there still would be an assurance of the identity of the item. But what you have here is you don't have Officer Lewis testifying that I removed the latex glove, that I opened the latex glove, I took out an item from the latex glove and weighed it. Instead, what he talks about is the other item. And the latex glove disappears, not in the exhibit, the photographic exhibit that is presented as evidence at the trial. And so you have this Officer Lewis testifying about, an Officer Lewis who, let's be honest, had committed perjury on multiple times in this particular case.
Let me ask you a little bit different twist on that hypothetical. Let's say you had a great chain of custody here. You have the same testimony. I took this thing, I put it in the glove, I put it in this envelope, I sealed the envelope, I signed it, I hand it to the next officer. That officer testifies I took it from the first officer, I took it, I carried it to the safe, I locked the safe, I got it back, I took it to the lab says I received it from that officer, same envelope, it's sealed, I open it up, and now it has the things that you've described it having in. Do you have a problem or no?
I'm not sure what you're talking about.
So same facts about
Right.
what's in that envelope, but now you have a perfect chain of custody.
If you have a perfect chain of custody, there's no issue here. We wouldn't be here, and Judge Wilson would never have granted me leave in this case. But that's not what you have.
Don't count on that.
You have something that she's testified to putting in that bag that doesn't match what comes out of that bag, right? In my hypothetical.
Okay, then you do have a problem. And that's partly what you have here, is that the description is that it is a badly damaged bag that was recovered by Officer Lynn.
No, I understand. My question, though, is if you have the chain, but you have the same facts on either end, you have the officer testifying this is what I put in there, but it doesn't match what they took out in the lab. But the chain is perfect.
Something
What
happened. We don't know what happened. It can't be a perfect chain of custody if the item
But
has
she could have made a
somehow
mistake.
been transfixed.
I made a mistake in what I thought I put in the bag.
Right, there could have been a reporting error on one end or the other with respect to the description, right?
So what happens?
Well, it's not if in a situation, if it's simply a reporting error, but this is not what you have. This is not a reporting error case. This is a case in which the item doesn't match. What the criminalist received was an intact bag that had no damage to it.
It's even more, troublesome, nettlesome than that, because the latex glove is not part of what was recovered from the defendant. The latex glove was something that Officer Lynn decided needed to be used at the scene at the time she picked up the envelope, because she thought, I guess, things were coming out of it. So with respect to this notion of reporting errors, it seems as if it's possible that someone decided to remove the latex glove because that was not part of the evidence that was collected from the defendant, and either failed to report that they discarded it or didn't think that they had to do that.
Your Honor, but that's not what happened here. When Officer Lewis says that what he found inside the envelope was the latex glove, which had been tied shut by Officer Lynn.
Yeah.
Officer Lewis does not say that I removed the latex glove, I untied it, took something out of that. What he says is there's a latex glove in the envelope and also this bag that is badly damaged and 45 glassine bags. Those are two separate and distinct things. If Officer Lewis had testified, I removed the bag, I untied it, I pulled those items
Counsel,
out of it, but
that
he
would
didn't.
That would suggest to me that if there's a latex glove and a bag that has another bag inside of it with 45 smaller bags inside of that, a lot of bags. But if Officer Lewis testified that he saw these two things, that suggests to me that maybe Officer Lynn, when she previously had the evidence, took those things out of the latex glove. She might have left the latex glove there, but she removed them.
That's not her testimony. Her testimony is she put the tied latex glove in the envelope. That is the sole thing that she did in that office. She did not testify that she removed anything from it, that she had tied it shut because the bag was so badly damaged that everything was pouring out.
And that's a serious inconsistency in the record. I'm just not sure how it goes to the chain of custody because everything is where it is supposed to be and being cataloged along the way.
Your Honor, but what you have is one item cannot become two items, and that's what you have here. Officer Lynn put a singular item into the envelope, a latex glove that was tied shut. What Officer Lewis finds in the bag is a latex glove and these bags. Those are two distinct differences, and those indicates that somewhere between the time that Officer Lynn put the latex glove into the envelope, someone else put a bag into that envelope as well.
I thought Officer Lewis also testified differently about the contents at different points in time.
Oh, absolutely, Your Honor. I mean,
It's not just the bags.
no.
It's also the actual criminal substance.
I mean, at times, he originally, in the felony complaint, this case, again, began through perjury. The felony complaint said Officer Lewis signed under penalty of perjury that he recovered 2 twist bags containing 4 ounces of cocaine from Mr. Baez's person. That's what started this case. Jurisdiction was obtained over my client through perjury. At the grand jury, he again commits perjury, where he says that he recovered 2 bags from Mr. Baez, each containing 9 grams of cocaine. Only until we get to the suppression hearing does Officer Lynn even come to the forefront, where it indicates that, oh, by the way, he recovered nothing at the scene of the arrest. It was Officer Lynn who recovered something. And then he talks about that his voucher doesn't match up. He says he weighed things and then he sent it to the police lab. But the problem with it is there's no damaged bag at the criminalist. Osorio doesn't find a damaged bag. She finds an intact bag. So something happened. Someone repackaged something.
The bag was admitted into evidence at trial, right?
A bag was admitted into evidence.
A bag.
A bag was admitted into evidence, but what Criminal Osorio testified to was that what she received was an intact bag that had no tears or anything in it. So therefore, even what Officer Lynn had said from the beginning, such a badly damaged bag that everything was pouring out, you couldn't have weighed it because it was so badly torn open.
You agree, though, don't you, that we have bags on bags on bags? There's a larger bag with another bag, and then 45 glassine envelopes within that bag. So
that's what Officer Lewis testifies to, but that's not what Officer Lynn, who's the recovering officer, testifies to. She refers to a single bag that contained a white substance.
And what about Ocasio's assessment of what is actually in the bag that Ocasio analyzed?
She says
How does it differ from the testimony?
that she found 5.35 grams of cocaine, which she described as loose solid material. At different points, Officer Lewis refers to it as in rock form, and sometimes it's in rock and powder form. There are so many different versions of what has occurred in this case that it is inconceivable to me that someone can say that the item that was allegedly recovered at the scene is the item that Criminalist Osorio tested. And because of that, there is these defects in the chain of custody as to both the identity as well as the opportunities to tamper with it. Someone put another bag into that envelope. That establishes under Connolly and under Julian that this isn't the same item that was recovered by Officer Lynn, and therefore Mr. Baez's conviction should be overturned and the case dismissed. Thank you, Your Honors.
Good afternoon, Your Honor. It's Chris Bluricosa for the Office of Melinda Katz, the Queens County DA for Respondent. Just to address the point about the glove at the precinct with the bags in it. Officer Lewis testified, this is on page, I'm looking at my adversary's appendix, page A221. He was asked by Mr. Baez on cross-examination, Mr. Baez represented himself, and he said, question, you said you recovered 2 twist bags. What did you recover? How many bags? Was it separated? Was it 1? Was it 5, 10? And the answer was when it first initially fell on the southwest corner, the little baggie was inside the big baggie, so that's how it was vouchered. Question, was 1 bag? Answer, I took it apart. So the contact he had with that bag is back at the precinct. Lynn left it at the precinct, told him where she left it on his desk. He goes to the precinct, and she left it in a narcotics envelope. He goes to the precinct and finds it in the exact same place. That testimony shows that he took it out of the bag and separated it. He also testified he photographed it. The photograph in our
But what
appendix.
about Officer Lynn saying she put 1 bag in the glove?
Right.
And what about Officer Lynn saying the bag was damaged, and Lewis saying the bag was damaged, and the criminalist saying there was no damaged bag?
Well, the criminal said she didn't see any holes in the bag, but if you look at the prosecutor's opening and
I think she says it was
summation,
intact. I think there was a lot of examination about that.
I don't recall if she used the word intact. I know she said she didn't see any holes in the bag, but when the prosecutor described the bag, which was in evidence during his opening and closing, he said it had...
A bag was in evidence, right?
No, both bags were in evidence.
Well, we don't know how many bags there were, right?
Oh, we know exactly how many bags there were. Lynn, when
You
she
might.
when Lynn testified, she explained, and I can give you the page site to this. This is Lynn at A308. She testified, I didn't count it, I just put it inside the glove, so
Lynn
she
at
didn't take it apart.
357. Lynn at 357, no, the envelope, the plastic security envelope that I received was not ripped in any way. Are there any holes in the bags? Which bags? Any of the bags? No.
Sorry, that's a
Found the bags, were the
350.
bags ripped in any way? There were no rips. I mean, 357. She's unequivocal.
This is a 357, you said?
Yeah.
But also, let me just go through the summation, the opening point I wanted
Well,
to make.
summation's not evidence as far as I was taught.
No, but the summation is discussing evidence that is in evidence, and without objection, the prosecutor said there's scuff
That's-
marks on it,
I'm sorry.
tears, rips. Mr. Baez didn't object, and Mr. Baez had a
You
lot
and
to
I have
say
a
during
very
trial.
different, you and I have a very different view of evidence, I guess, which is that if the prosecutor says something that is not in evidence and there's not an objection, that makes it in evidence.
I don't think we have a different view of evidence. What I'm saying is that the prosecutor's remarks were not objected to. If
So
that
what?
bag was not described
So
that
what?
way, if the bag didn't look
So
like that,
what?
somebody would have objected. His silence speaks volumes
This is a
about
pro
it.
se litigant, and you're saying we should then treat this as evidence? This is really
This
like
is a
beyond the
pro se
pale.
litigant. This is a pro se litigant who, if he went to law school, would probably make a great lawyer because he had a lot to say.
Right.
He
But
was
what we
never
do
silent.
have-
He objected
what
to
we-
everything.
So why don't you get back to my question, which is we have sworn testimony from the officers, both of them, that the bags were torn, that material was falling out of them. They had to be put in a latex glove to secure the evidence. And what gets to the criminalist? There are no torn bags, no rips, no nothing. Isn't that
The
troubling
criminalist said that she didn't, no, it's not a problem because all the voucher numbers match up. It's the same voucher number. So what about that? That means nothing, that it had the same narcotics number, the same voucher number,
That means-
same bag number. It was sealed when it got there. Maybe she just made a mistake. Maybe she didn't see it. All the numbers match up. You can't discount that evidence
I'm
based
sorry,
on
what
her.
are all the numbers that match up? Let's do the little breadcrumbs. What are all the numbers that match up?
The first is the invoice number. That's on the voucher. That lists the evidence. The second number is what's called the PETS narcotics number. That's on the narcotics envelope. Then the voucher and the envelope and the evidence are put inside another bag that's got a third number on it. All 3 of those numbers match up. Everything was sealed and signed when Osorio received it. She testified to that, and she said she resealed it. At trial, they both testified that, yeah, these are the same numbers, that's my name. She testified to her name on the report.
So then you understand that to mean they both made mistakes in their descriptions.
Osorio may have made a
Because
mistake.
whatever went through, despite the fact that each of them are saying, or all three of them are saying something different, the numbers match up, regardless of the fact that at some point in time, the prosecutor failed to put into evidence that there's a point in time when it appears no one is supervising the envelope.
Well, I mean, I don't think we have to put in that person, you know, I mean, look at Hawkins, the evidence was
What do you
left
do with all
alone
these discrepancies?
with the
It doesn't trouble your
I-
office that you have these officers who don't even know what they're picking up, when they picked it up, how it gets it in one place and ends up looking completely different in the other place?
Oh, no, I'm not saying our office doesn't encourage accuracy in police paperwork. Sometimes it doesn't happen. This paperwork is not a
discouraging
model of clarity,
inaccuracy.
admittedly. But again, that goes to weight, doesn't go to the chain of custody, doesn't go to admissibility. Just to go back for a minute, Officer Lynn testified it was one bag. Then we have the testimony from Officer Lewis about finding the glove that Lynn said that she left in the office in the exact place where she said she left it. Testimony says he took it apart, he photographed it, it's clearly two bags, right? So any discrepancy there is explainable. Lynn didn't look at it when she first recovered it. Why? It was spilling out. She isn't going to take it apart there in the street. But it,
And he was also wrong that he thought he had recovered it from Mr. Baez, just to clarify.
no, they call that perjury. I think that's just.
No. You understand and recognize that's a discrepancy.
No,
You're trying to
that's
make it
not a
seem-
discrepancy at
It's not a
all.
discrepancy that he thought he recovered it, and you have another officer who says, I recovered it.
She picked it up off the floor, but they're partners recovering the same evidence. He vouched it. If anything, his role in the process is more important than hers. Just picking it up off the floor is not how evidence is
So it's a
quote recovered. You got to vouch for it
misunderstanding
too.
it's a misunderstanding in terminology?
Yeah, I'd just say maybe he spoke in a broad fashion about the fact that he recovered it along with his partner.
What about twist bags, 2 twist bags with 4 ounces of cocaine? And I checked on Google, 4 ounces of cocaine is about like 120 grams.
They're different, yeah.
It's a
but
lot.
The common way criminal complaints are written up in the 5 boroughs is that the ADA or the paralegal writes them up. Officers don't write them up. I don't know how it's done in other counties. He obviously didn't read through this carefully enough before he signed
So
it.
that's just bad record keeping on his part?
That's bad record keeping on everybody's part. It was a mistake that should have been made.
Because he just doesn't know what it is?
Excuse me?
He doesn't know what it is? He
I'm not
doesn't
following.
know what it is on the record keeping and this discrepancy, doesn't know what it is he's identifying in the record?
No, he did identify it on the record by his name and by the numbers that he assigned to it. There, I think he just didn't read the complaint accurately. And that led to the discrepancy. I think what's more important here is that this evidence was kept in police custody at all times. It wasn't like the evidence in Hawkins that was just left alone in a room.
So to go to Judge Garcia's question to your adversary, is it your view that if the chain is established really very cleanly, that no discrepancy would be problematic, no matter how severe?
I mean, that's basically what this court said in Conley. I mean, reporting errors in paperwork don't change the essential nature of what's recovered. There's nothing on this record that the actual evidence itself changed in any
Okay, well,
way,
what if it was a different substance?
such as,
Instead of, you know, instead of what was recovered, it was a different type of drug altogether?
a different type of drug, like
Yes.
from cocaine to heroin, then that's a problem, yeah. No,
Okay,
that
so
would be a
there are
problem.
some discrepancies that would give rise.
But not in paperwork. I'm talking about the actual substance.
No, I'm talking about the paperwork.
No.
So no matter what it is, no matter how varying the descriptions are, that's irrelevant to a chain of custody inquiry, period.
Well, it's not irrelevant. It does go to weight. It doesn't go
Yes,
to
I
admissibility.
understand.
So, and that's where it begins and ends. That's Conley.
But you've
That's
got a
black letter law.
problem. You've got a problem in testimony. You've established what went in the bag here, went through the process and ended up here. One, I don't understand the drugs because you don't know what it is till you test it. But you have something that goes on here, comes out the end here. You think it's the same thing. It just doesn't match the description of the person who put it in the input side. To me, that seems like a testimonial problem, not a chain of custody problem, right? There's a problem with the testimony.
I mean, it was described, I mean, look, it was cocaine. That's how it was recovered. That's how it was tested. In the voucher, it was described as rock. Powder was left out. They made a big deal about that at trial. But the criminalist testified that, yeah, it was a loose, solid material, which would include rock and powder. You know, just because he left out the powder description doesn't mean it's a different substance. Again, these are reporting errors. There was no claim ever made that what was entered into evidence, that it changed in any way, that it went from a solid to a liquid,
So
or from
do
a
you
this to a that.
agree with Judge Garcia? It's not a chain of custody issue, but it's a weight consideration.
Basically, it's a weight consideration. And all the discrepancies.
And what does that mean? What does that mean? That the court has to decide, I just don't believe you?
No, I mean.
When the court is hearing the testimony, is deciding, I think that's incredible, I don't believe you.
If the court just doesn't
Is that what you mean
believe-
by- I just want-
No, it goes, it becomes a jury question at that point.
But
Then it
again,
can
the
be submitted
weight
to the
is
jury.
is the issue of the weight. The
Right.
credibility determination or something else. That's what I'm asking.
Right.
Yeah, I
you
mean,
say it
it's
goes
not
to
so
the
much the
weight.
credibility of only the testimony, but also the inconsistencies, how to resolve them, and finally deciding the case. As far as admissibility goes, I don't know if your question is, do you take those into consideration in terms of the weight
What's the
analysis?
value
Well,
of
I'm trying to,
determining
I'm trying to
admissibility?
appreciate the acquittal of the other counts.
Right.
So that's why I'm asking, is it a credibility issue or it's something else? Because perhaps that might explain the actual verdict.
Yeah, I mean, I think it's something else that goes to the verdict. For example, he was acquitted of the possession charge, so
Yeah.
maybe the judge accounted for the fact that the 45 glass scenes weren't reported. That would go to the third-degree possession
Okay.
count because, intent to sell. He was acquitted of the tampering charge. You know, so maybe the fact that that wasn't recorded in the voucher, I don't know for a fact. Maybe that entered into the judge's logic. Maybe, threw him a freebie and said, okay, here, fine, it wasn't recorded, I'll give you the acquittal on
Talking
that.
about the judge's fact finder, not the judge's
Yeah, this is a bench trial, right?
law,
Right, it's a bench
trial.
trial.
Yeah.
I mean, as far as admissibility goes, this is actually more than enough. This is more than you had in Hawkins,
Well, you had in,
Hawkins at 11 New York
Yes, yeah.
3rd. The evidence wasn't even left alone for a long period of time. The arrest or the incident occurred at 11:21 or so on February 4th of 2014. It's brought to the precinct. It's not clear when the exact time Lynn drops it off at the precinct, but
it's a similar question to Judge Halligan's, but I think slightly different. What if the testimony is consistent that what went into, let's stay with the glove that then goes in the envelope, is in rock form? Not in a powder or smooth powder, just rock form. But when the criminalist opens it, there are no rocks. Do you say that goes also to the weight?
you mean it's in powder form instead of rock
Yes,
form?
as opposed to the crystals, the rocks, yes.
I mean, it probably would go to weight because it could be crushed during the transportation process. I mean, if there's some explanation for it, I think it'll be okay. But, again, we're talking about the form of the actual substance now. We're not talking about reporting errors, which consistently courts have held only go to weight.
And if the
not-
criminalist said, if it was a rock, it would not in transport have ended up with this kind of powdery residue.
If the criminalist
Said that what you just described as the explanation was not possible. You still say that still all goes to the weight.
I think it would go to the weight because that would be pretty strange testimony, that a rock could not go into powder. I mean, cocaine can easily crumble. I mean, that's, you
Well,
could
let's
have.
No,
the
but
take it
my-
this way.
my-
Say it
my-
starts
my-
as powder and
yeah.
ends up as rock.
Or the other way, yeah.
Yeah, I mean, I think what goes to admissibility would be more of a more drastic change than that, like in color, or a real change, like from, say, a solid to a liquid or something, where it's clearly, it can't be the same thing. But for rock cocaine to go to powder, and then you're saying it's not the same thing, that's just not the way it is.
So some change conditions, you're saying, can go to admissibility and not weight?
Some change conditions, but I'd say it has to be pretty drastic. I don't think it's just rock to powder. I mean, I think that can be discounted. I mean, if the criminalist said that, fine, but, it's up to the judge to make that ultimate determination as to
Then it-
admissibility.
Yes, so then when you are talking about weight, you say it's not about admissibility, it goes to the weight, it's about a credibility determination. I believe you or I don't believe you. I believe that the criminalist says that's what they found, or I don't.
I think weight that goes to more of what the jury does, that the fact finder does, not in the process of determining
But
whether
again,
something's
that's
admissible.
what I was trying to get to, what you mean by weight. I'm left
That-
with, it
that's-
must be a
that's what I mean by
credibility
it.
determination.
You know,
Unless the
and-
criminalist said, no, there's an explanation. This change is certainly possible.
In terms of your example with the rock into powder?
Or the powder to rock, either way.
I mean, she could say that. I don't think that's the kind of change that cases talk about where it becomes inadmissible. You know, something going from just rock to powder form. If there's like a change in color, I mean, that would be quite odd if there was a change again from solid to liquid or something like that.
And you would
You
say
know.
then that doesn't go to the weight?
That would go more to admissibility, like a drastic
Because it's
change
simply
in what the
impossible?
substance is.
Because it's simply impossible? Is that-
Because it just wouldn't make sense unless explained. If it can be explained, that's another thing. You know, if it changes color because of the testing process, let's say, and the
And
criminal
you say
testifies to
here, there
that.
is an explanation, in your
For all
view?
the inconsistencies, yeah.
Yes.
Yeah, I mean, Lynn says one bag, he took it apart and saw two. Criminalist says, yeah, I saw the 45 bags in there, which is what he saw at the precinct. In the arrest report, he's charged with sale. That's another thing they brought up, but he was never formally charged with sale. He
And
was only charged with
if what
possession.
Lynn got was, everything is the same, except what Lynn got was some white material that turned out to be cocaine in a pickle jar, that's weight. Has the label on it.
That'd be extremely odd, Judge, and, you know,
Yeah, well-
would deserve a very thorough inquiry. It's not what happened here. I've never heard of that happening, and I hope that never happens, because that would be pretty bad. But yeah, I mean, you know, a case like that kind of arose in, I think the case was Dunham v. Melly, where somebody brought blood to a lab, right? Gave it to somebody they didn't identify or couldn't identify. And then the person at the lab put a label on it. And then the person that tested said, well, the vial doesn't have the label. The label was on the box instead. And the third department, it was a 1961 case, the third department ruled that there wasn't enough to meet the chain of custody because of this mislabeling. So, you know, that predates Conley. I don't know anymore if that might go to more of a weight question or an admissibility question, because it's still the same, still argues the same vial of blood, you know. Your question of a pickle jar, it's, I hope that never happens.
Me too.
That's how I'll answer that. I hope we never get a case like that, because that's a much more difficult argument. But this case, it's pretty simple. It's always in police custody. You got the voucher numbers. You have 3 witnesses, not just Officer Lewis testifying to the chain. There's no evidence of tampering. There's speculation of tampering. But what he's saying about the bags, nobody planted the bag. That's explainable by the testimony and the fact that Lewis took everything apart at the precinct. So for all those reasons, the chain was made out, everything else goes to weight, and we ask you affirm the appellate division's decision.
Thank you.
Your Honors, it's not simply paperwork errors. Look at Officer Lewis's grand jury testimony when he says there's no mention of Officer Lynn at all. He says he personally recovered the 2 items from the ground. Each one contains multiple Ziploc bags and crack cocaine in the form of small rocks, a white substance, and powder. And what no one and my adversary has not been able to dispute is there are 2 items in the envelope. Officer Lynn only put 1 item in the envelope. She put in the envelope a Tide latex glove. She did not put in a Tide latex glove and a bunch of other bags. Officer Lewis does not testify, I removed the latex glove, I cut it open, I removed it, and then weighed those items. His testimony is what I received or what was on that desk in that envelope was 2 items. 1, a latex glove, which disappears and is never seen again. He does not testify he opened it or did anything to it. He did not photograph it. But what he also says is he recovered a 2nd item, which is the bags that are in question. That showed up between the time Officer Lynn put the stuff in the envelope, the latex glove, and when hours later Officer Lewis came to the precinct. He finds 2 items in that. That establishes that what Officer Lynn recovered is not what was sent to Criminalist Azario for testing.
Let's say, I'm sorry, to go back and hate to beat this more, but same facts here. Officer Lynn takes the envelope, seals it, boom, you don't see that, but she comes in, she puts it on the desk. There's a video camera there, and it's watching this 24/7. The next officer comes in, takes it on video camera, brings it to the lab on video camera, the lab opens it, dumps it out, and it's different things than what she says she put in the envelope.
Then
What's the end result of that?
Her testimony would have been false at that point, because
Or
it's
she misremembered it, or she made a mistake. And isn't that what you mean by weight? Because
No.
depending on how strong the chain of custody is, depends on what happened here, right? So if your chain of custody is bulletproof, that it's this thing that was put in the envelope that got to the lab, then a mistake has to be made at this end in terms of what she thinks she put in that envelope, what she remembers she put in that envelope, what she wrote down she put in that envelope. So isn't that what we're really getting at here? How firm is the chain of custody? So how much does that indicate that she made a mistake versus there was tampering somewhere along the
She
line?
did not make a mistake. Her testimony was crystal clear throughout her testimony, that she recovered a single bag that was torn from the ground, that was so badly damaged that she needed to put it into a latex
How long after
glove.
that event was she testifying? How long after she recovered the drugs did she testify in court?
It was, it was a long period of time afterwards, but she has, and Officer Lewis also testifies that she put the bag into the latex glove. So it's not simply Officer Lynn testifying that she put the bag into the latex glove. Officer Lewis also testified that she put the bag into the latex glove. So therefore, when she then testifies that she put that into the envelope, and then Officer Lewis comes hours later and finds 2 items in that,
But
that
under
came
my
from somewhere
scenario,
else.
Same testimony, we'd have to assume they made a mistake, right?
I don't believe they made a
No,
mistake.
but in mine, where the whole thing's on video after.
If it was on video, then you would have the proof that she misremembered. Here, you have both officers testifying what Officer Lynn did at the arrest scene, and that was to put the bag into the latex glove and to tie it shut. But what's in the envelope is 2 separate and distinct items. If he had testified that he removed the latex glove, opened it, we'd be in a different situation, but he doesn't. The latex glove disappears, never photographed, and by the way, Criminalist Azario does not identify they had the photograph that Officer Lewis took. The people never asked Criminalist Azario, is this what you received? They didn't ask her that question. There is a gap. There are gaps in the chain of custody. This evidence was tampered with, and Mr. Baez's conviction should be overturned. Thank you, Your Honors.
Thank you.
And I'll see you next month on Search and Seizure Day.